Yes.
But I beg to mention item 15 and 16, my lord. These are those enforcement matters, my lord. Mr. Shulai is just.
Yes, what happened to this?
The matter in Supreme Court is about to be listed, my lord. Service is just completed, so it's about to be listed.
But Mr. Shulai the other day said these are not connected with what is there before the Supreme Court.
If no, because the objection came from the state. If that objection is not there, then we can go ahead, my lord.
What do you
Come
say?
up tomorrow, day after, anytime, my lord.
Let it come after a week, then, Your Lordship.
No, you see, it's your case. You think that this case has got a bearing with what is before the Supreme Court?
Because, Lordship, what happened as of now, because by virtue of the judgment of the division bench, Your Lordship, they were relocated, Your Lordship,
Yes,
to their original position. So, in that view of the matter, Your Lordship, they will have no grievances against both the advertisement. But suppose, Your Lordship, since they have filed SLP before the Honorable Supreme Court challenging that judgment of the division bench, so if that judgment is set aside, yes, they may have a cause, Your Lordship.
And both
There are
the
two, I think, as far as they are concerned, it's their prayer is twofold. One is on the basis of promotion, and the other is on direct on qualification.
Yes, Your Lordship.
qualification. And our case is irrespective of the procedure, whether by seniority or whether by qualification, we qualify in both. And the other parties have filed the SLP, including the state. So state has also filed.
Okay.
Next week, my lord, we'll try. We can start and then we'll see how it shapes.
Fine. 15, 16.
15, 16, my lord.
15, 16, no? On play made by the parties, indicating that there is a similar matter, indicating that there's a matter before the Honorable Supreme Court dealing with similar issues as is present in this petition, which will have a bearing on this petition, on the merits of this petition. It is prayed that this matter may be adjourned for the time being. As prayed for, this is matter after 2 weeks. Let's put it. When is the matter coming up through the Supreme Court?
My lord, recently there's a direction for listing. According to the listing, my lord, there are no fixed dates.
It may take time, we don't know.
Yes, my lord.
Fine, 2 weeks then we'll see.
Yes, my lord. Deeply.
Study the matter.
May it please Your Lordship. Lordship, item number 19 and 20, Your Lordship, I have a prayer, Lordship, for adjourning this. I'm supposed to file the bullet point argument, Your Lordship. I'm yet to...
It'll be a joint prayer, Your Lordship.
How long?
10 days time, Your Lordship.
2 weeks.
2 weeks.
2 weeks.
Prayer made by the Leonard AAG, seeking time on behalf of the state respondent. Matter is adjourned. This is matter of 2 weeks.
Apply,
You
Your
have filed
Lordship.
yours, Mr.
Joint prayer,
Punjab?
Your Lordship. Joint prayer first.
Oh, joint prayer.
Yes, Your Lordship.
Prayer made by the parties.
Apply, Your Lordship.
Your Lordship, I beg to mention item number 13, Your Lordship, if this matter may be taken up after 2 weeks.
Thirteen.
13.
How long?
2 weeks, Your Lordship.
On prayer made by the petitioner. This is matter of 2 weeks.
Much obliged.
May it please Your Lordship, I beg to mention item number 10.
Then
Yes, Your Lordship. I pray for 1 week's time, Your Lordship.
this is fixed for filing of written argument, isn't
Yes,
it?
Your Lordship.
We are not ready.
We have already filed the written argument, Your Lordship.
Then what is required?
Instead, you have to file the written argument, Your Lordship.
Yeah. So why are you asking for time?
Because
should
the
ask
landed
for time.
arguing council, Your Lordship. Instead of
They
station.
should ask for time. Why?
It's a joint request, Your Lordship.
Yes, Miss.
Lordship, this matter has been endorsed to Mr. Singh Gupta, and he also asked for 1 week's time.
On pre-made by the parties seeking time to file the pre-made by the parties. This is matter to 1 week.
Your Lordship. Please, Lordship, I beg to mention item number 18 in my note. Your Lordship, I pray for 2 weeks' time as we were supposed to file a written synopsis in this matter.
Yes, who's appearing for the state? Mr. Sen is not here.
My lord, we have to find written submission in this matter. So, my lord, and for the appellant, my lord.
Have you filed in your
No,
order?
my lord, we have not filed yet.
On pre-made by the parties seeking some more time to file an argument. Matter is adjourned. This is same after
2 weeks.
2 weeks.
Thank you, Lordship.
Yeah, please, Lordship. Lordship, I beg to make a mention for item 11, Your Lordship.
Item number
11, Your Lordship. Lordship, Mr. Paul is having some difficulties, Lordship, today, so I pray the matter may come next week, Lordship.
I think this court has made it very clear. This is 2015 matter.
Yes, Lordship.
We cannot go on like this. You are for petitioner?
Yes, Your Lordship.
This is with regard to the lease.
Lease, Lordship, yes, Lord.
There's a stay order. Is
No,
there a stay
Lordship.
order?
No, Lordship.
Why are you seeking for time here?
Lordship,
What's your ground?
Lordship, Mr. Paul is out of station, Lordship. That's a problem. I pray the matter may happen next week, Lordship.
If Mr. Paul is not there, there are other colleagues of his here. You are there. I think I've indicated in my order no more time is happening. 11. I'll give you a last chance. And whether you are there or not, we'll dispose of the matter. Once again, the petitioner has sought for accommodation in this matter on the ground that the Leonard Senior Counsel who is conducting the matter is out of station. It may be noticed that this matter is handled not only by one counsel but by others. It is imperative that the matter be taken up seriously by the parties, considering the fact that this is a very old matter pending before this court. Be that as it may, on the prayer made, the same is allowed. It is, however, made clear that no more further adjournment will be allowed on the next date. Parties are directed to make a suitable arrangement for the same. This matter is listed to be heard on 28th.
Should I have some similar prayer for item 14 and 17, Your Lordship? Lordship, this
14.
yes, Lordship.
What is this matter?
This matter is regarding the tender of the issue tender of the settlements of fisheries, Lordship.
Fisheries. Oh, those.
We have
I think
challenged.
this matter has been. Anyway,
Lordship, in this matter, have indicated us to take fresh step with regard to this respondent 5, Your Lordship, but so Hazarika is appearing in this matter for respondent 5.
okay, then as and when it's taken up on pre-made by the petitioner, this is matter up to 2 weeks. You are there, Mr. Dev?
I'm for district council. Item 17, Lordship.
17?
17, my lord, last time on
Oh, same thing here.
Lordship will allow to have the matter next week, Lordship.
Mr. Paul is out of station. What do we do?
last chance may be given, my lord.
Last chance, how many,
Otherwise, it will continue like
how
that.
many last chance we'll give? How many times we have to change the dictionary?
After last chance comes final last chance.
And after final last chance, then final chance. Then after that, then chance. You take your chance. On prayer made by the petitioner seeking adjournment on ground of the fact that the Learned Senior Conducting Counsel is out of station, that is adjourned. It is, however, made clear that no further adjournment will be allowed on the next date. Parties are directed to make suitable arrangement for the same. This is matter after 1 week.
Leo Blash, Lordship.
Legal cause list, item number 1.
Lordship, in this matter, we bring some more time to file rejoinder, Lordship. Give us 1 week time, Lordship.
2022 matter.
Yes, Lordship.
By now, rejoinder should have been filed. Reading should have been completed. Then you take your time to seek adjournment for hearing of the matter for the next 3-4 years. Finally, after 5 years, we'll definitely finish this now. How long?
Give us 1 week, Lordship.
Then the counsel for the petitioner has submitted that the rejoinder affidavit could not be filed today and has sought for time. On prayer made, the same is allowed. This is matter after 1 week.
Leo Blash, Lordship.
Item number 2.
My lord, here we have to file the counter affidavit, my lord. We'll file it within 2 weeks, my lord.
What is this matter about?
Assam Rifle School, my lord, pertaining to the 7th CPC.
Oh, sorry. Mr. Ensign Learned Counsel for the respondent ERPS
My lord.
has sought for time to file a counter affidavit on the ground that the same could not be filed today. On pre-made, the same is allowed. Respondent number 1 and 2 is not represented today. The said respondent has also not yet filed their counter affidavit. The same may be filed within the next date fix. This is matter after 2 weeks.
Item number 3.
My lord, I'm for the respondent number 5. I've obtained the death certificate of the
Oh,
yeah,
she's has expired.
but the thing is that there was some tropical errors in the death certificate, so we have applied for correction. So we need to receive more time for.
Who's it for the petitioner?
Your Lordship, it's me, Your Lordship.
knowing that it has been submitted that the respondent 5 has since expired, it's incumbent upon you to take steps for substitution.
Yes, Your Lordship, but we have it's yet to provide the name, Your Lordship. We need the name.
Even otherwise, also you get informally you get the name of the legal representative from the council.
Yes, Your Lordship.
Take steps. In the meantime, for
We'll
confirmation
seek
of the debt, file the debt certificate. Learned Mr. Sankija, learned counsel for the respondent number 5, who is since deceased, has submitted that the death certificate could not yet be filed today, could not be having been obtained. There are some corrections to be made as far as typographical errors are concerned, for which a proper death certificate is required to be obtained, and thereafter a proper petition will be, and thereafter a petition will be filed before this court, officially informing of the said death of the respondent 5. In the meantime, the petitioner is also directed to take steps for substitution of the said deceased respondent number 5. On pre-made, this is matter of 2 weeks.
Much of
Item number 8.
Your Lordship, here the respondents are yet to file their affidavits.
I'm appearing on behalf of the respondent number 2 and 3, my lord. I pray for 2 weeks' time in order to file the counter affidavit.
What about the state?
Respondent.
Make a similar prayer, Your Lordship. 2 weeks time, Your Lordship.
Learned counsel for the respective respondents have made a prayer for the counter affidavit to be filed within the next date fix, on the ground that the same could not be filed today. Accordingly, on prayer being allowed, let the counter affidavit be filed within the next date fix. How long?
2 weeks.
This is matter to 2 weeks.
Item number 9.
Earlier we were given the liberty to file, submit our detailed submissions. So today we have filed. My friend also has filed, I think.
Both of us have filed. We have exchanged the copies of the written submission also.
But I would very humbly submit, if in addition to this also we have given an opportunity to make some oral submissions.
Yeah, in fact, that was supposed to be the case, where you are to, first, orally place your argument, and then there's written submission to be filed later on. But you have done it
reverse
way, but it doesn't matter. You just have to.
In fact, we had made our submission earlier once, long ago, Your Lordship. That was pretty long back.
Quite. This court would, just recall, vaguely recall the facts.
Yeah.
So, please start, Mr. Chiprati.
Oral submission?
Yes.
do it today.
If Your Lordship could kindly accommodate us on another date, because I have some to rush to the other courts.
And we have just received also. We'll just go
Each
through.
other's copy. We just
We'll just go
received it
through
now.
also.
We'll go through.
1 week?
1 week will suffice.
Well,
Your
good.
Lordship.
Learned counsel for the learned senior counsels appearing for the respective parties have submitted that the written argument on behalf of their respective clients have been filed. It is, however, submitted that the oral argument may be allowed to be advanced to substantiate the same. On premier, this is matter to 1 week.
Obliged.
Obliged.
Item number 12.
Let's go upon Paul. Paul.
May it please your lordship, I prefer some accommodation. Your lordship.
Why did you jump the gun? He was about to.
Your Lordship, no, Your Lordship, Mr. D. Thaba, Your Lordship said he's on his way. So he prayed that matter may enter the boat, but
see, one way or the other, one party or the other will ask for time. This matter has been heard, wasn't it?
Is it?
No, Your Lordship.
This is with regard to that notification.
Suspension, Your Lordship.
It's the cancellation of the mining lease.
Oh, cancellation. Cancellation.
By the union.
Oh. And who has cancelled the state?
Madam, your union.
Union?
The ministry has cancelled.
Excuse me. So pleadings have been completed then?
Yes, Lordship. Actually, Lordship, in this matter, we have filed a miss case.
No, what is the miscase about?
What's the status quo, Your Lordship? But actually, as per instruction from Master Conducting Counsel D. Thaba, Your Lordship said that some submission to be made regarding to this miss case, Your Lordship.
Yes, I think you are required to seek instructions. Yeah.
No, my lord, we are not. In fact, my lord, state has apparently, as per the pleadings of the writ petition, my lord, entire allegations against the union because the license is issued by union, my lord. The union again found that there was some discrepancy. It was cancelled, my lord. So they have challenged the order, which is at Annexure 14, my lord. That is the impugn order here. So, my lord, we have been appearing since the day one of this petition and this particular file as a formal party. This matter was heard by Justice. Thank you, my lord.
Yes.
It was heard, my lord, during the course of the argument by the senior counsel who was appearing for the petitioner. He made certain allegations, a number of allegations against the state, my lord. So, pursuant to that, the court has directed the state to file an affidavit in opposition. We have also filed an affidavit, my lord, because there is no whisper against the state. It was in the argument that was raised. So, we have filed. So, my lord, then just a few months back, my lord, they have filed a miss case, praying for status quo, my lord. So, this status quo application was also not entertained by, if I'm not mistaken, my lord, Justice Court number 2 has not entertained it.
You know, I think what's the last order? Yes, the last order, in fact, the only order in this case is for instructions.
My lord,
to be sought for by the parties, respondent.
Respondent 4, 5, and 6, Lord.
my lord, the last order is first September.
No, you in the miscase.
No, my lord, I believe that is wrong, my lord, because we do not
23,
have any, we do not have anything against the miscase also.
Have you
This is, my lord, I believe.
go to the order of the miss case?
No, my lord.
You have a copy of the order? Show it to them.
My lord, this submission was not based on the fact that the petition was not served upon us, my lord. The petitioner has served the copy only to the union because they are the main answering respondent. So that a submission was made based on that, my lord. So after we have produced the miss case, my lord, we don't see any reply to be made, my lord.
But what purpose would it serve? You see, as far as this petition is concerned, if the main
My lord,
this
exactly,
petition,
that was
main
what-
petition is to be heard, that would answer all your grievance. If
the main petition covers the entire
It
issue.
would be, it should
so
be.
Filing this miss case apparently for status quo, my lord, when the writ was filed way back in 2021, 2023, my lord, they're filing this miss case. My lord, which is why this miss case was not entertained. However, it was not disposed of on the prayer made by the counsel for the petitioner.
what do we do? You're not prepared to be heard.
I know, Your Lordship. I paid for 2 weeks' time.
The counsel for the respondent, Union of India, has. What is your ground? What is the ground of your?
In order to prepare the matter, in order to seek instruction as well, my lord, for the miss case.
Has submitted that this matter may be allowed to be adjourned on the ground that the respondent is yet to receive the instructions as far as the miss case number 92 of 2023 is concerned, which miss case is part of the proceedings hearing. On premier, this is allowed. This is matter to 2 weeks.
Item number 21.
My lord, what has happened here is the court has the court below has dismissed my complaint, taking recourse to section 256 CRPC. Now, my lord, when a complaint is dismissed by taking recourse to this particular provision of law, it amounts to acquittal. Now, my lord, this provision can only be invoked when the parties have put in appearance. Now, in this case, what has happened, this is a long, my lord, this is a long pending case. This case, in fact, has a checkered history. It has come through this from the Supreme Court. It has gone to the High Court. Then again, the matter was before the trial court. The matter relates to a complaint filed under 138 of the NI Act. Now, my lord, the impugn order, my lord, will find at page 16. Now, my lord, in page 16. My lord will kindly see, steps were taken to issue BWA against the accused person. The complainant filed a report indicating that the BWA was not executed due to insufficient address.
Yes, page 16.
Page 16. 16.
Yes. Case record put up before me today.
Yes, yes. I'm on para 3, the last line. It says that on the complainant filed a report indicating that the BWA. What has happened here, after the complaint was filed, steps were taken, the opposite party, the respondent did not respond. So thereafter, the court was pleased to issue BWA, bailable warrant of arrest. Now, BWA was sent BWA was sought to be enforced through the local police station there. There also it could not be served. It could not be served. So therefore, we appeared before the court and we said that the BWA could not be served. However, at this stage, the court dismissed my petition since the counsel that I had earlier engaged failed to put up an appearance. The court dismissed the petition, taking recourse to 256. Now, 256 can only be taken recourse to when the parties have put in their appearance. 256 categorically provides that.
What does it say? Who's appearing only?
My lord, we have taken steps. Nobody has appeared. Nobody has appeared. Nobody has appeared.
We have taken steps.
Yes, please. We have taken steps. They appeared before the High Court, then they appeared before the Supreme Court also. In the same address. And on the same address, I took steps.
Have you filed your affidavit of service?
I filed it. Your Honor, there is one difficulty. What has happened is I had some case laws prepared for this case, but unfortunately yesterday I was informed by my junior that there has been a bereavement in the family. So I'm not armed with the case laws. So if Your Honor can have it on any other day, maybe tomorrow. Otherwise, the provision of law is quite clear. The provision of law is quite clear. In my grounds also, I have taken these. In my grounds also, I have relied on. I've cited certain case laws.
So against the order passed under 256, you have come before the court?
Yes, by way of criminal petition under 482, because there is no provision for appeal.
Okay. So tomorrow?
Tomorrow, I'll come up with the case laws.
Mr. K.C. Gautam, the counsel for the petitioner, has submitted that he is not prepared to be heard in this matter today and has sought for same to be heard tomorrow. On premed, seems allowed, this is matter tomorrow.
Tomorrow. All right.